Cody, I just got an email from Scott. He's having some issues.
Now, you ready to get started?
Sure. So we ready to call this meeting to order?
Yes, are we ready to record, Laura? Or whoever's recording?
Yes, ma'am, it is recording.
All right, we're ready.
All right, so we'll call this February 26th meeting to order. And Ms. Vest, if you would call the roll.
Thank you. Scott Cockcroft?
Here.
Doug Fraker?
Here.
Lou Richard?
Here.
Keith Harvey? Let the record show that Keith Harvey is not present, but you do have a quorum, Mr. Chairman, which is Scott Cockcroft today, who is our vice chair.
All right. So then do I have a motion? What do we need to approve the agenda? Is that our first?
Yes, so we need to adopt the agenda by roll call.
Make a motion to adopt the agenda as presented.
No, second.
All right, we have a motion and a second to adopt the agenda. Would you call the roll?
All right, Scott Cockcroft?
Aye.
Doug Fraker?
Aye.
Lou Richard?
Aye.
Motion carries.
All right, and so what's our next?
Minutes. We're going to adopt. We need to adopt our minutes.
Yes.
Oh, no, wait a minute. We need to do a statement of necessity by our staff attorney, please.
Okay.
So I'll just read that into the record now.
Mhm.
This is the regularly scheduled meeting for the Tennessee Alarm System Contractors Board, which is taking place via video conferencing means pursuant to Governor Lee's Executive Order number 16 and extended by Executive Order number 65. Meeting remotely is considered a reasonable measure to protect the safety and welfare of Tennesseans while ensuring government business may continue in a manner that is open and accessible to the public. All votes by the board will be by roll call. Notice of the meeting date, time, and location has been posted on the Tennessee Alarm System Contractors website since September 30th, 2020. This month's agenda was posted since February 19th, 2021. Pursuant to Tennessee Code Annotated Section 8-44-108B2, if a physical quorum is not present at the physical location of a meeting of a governing body, and in order for a quorum of members of the governing body to participate in the meeting by remote means, it may be acceptable if a necessity exists and a statement of necessity is read into the record. The determination must include a recitation of the facts and circumstances for which it is based. A necessity is determined by the matters to be determined by the governing body requiring timely action. A physical quorum is not practical within the time requiring action, and that participation of a quorum of the members by electronic means is necessary. The purpose of today's meeting is to discuss the meeting agenda, which has been previously posted to the board's website, and voting will be done by a roll call. Thank you.
Okay, Jesse, thank you. All right, Mr. Chairman, we're down to adopting our minutes, please.
All right, so do we have a motion to adopt the minutes from our prior meeting?
I'll make a motion to adopt the minutes.
Second.
All right, so we have a motion and a second. Ms. Best, will you call the roll?
Scott Cockcroft?
Yes.
Fraker?
Yes.
Lou Richard?
Aye.
Motion carries to adopt the minutes, Mr. Chairman.
All right. And I apologize. I'm having a hard time finding now the document. I had the document that had all our stuff in it, and then I couldn't find the link to the meeting.
That's okay. Well, next thing on it is election of officers. So I need to ask you a question. This board right now only has 4 members, and of course, there's 3 of you present today. You need a chair, vice chair, and a secretary. So do you want to go ahead and elect officers, or do you want to postpone this to the next meeting when all 4 of you are present?
I would think we should wait until we have Keith here as well.
Any other comments from our members?
I agree.
Okay. I probably need to get a motion for that.
Mm-hmm.
Okay.
Scott, I need a motion to postpone the election of officers to our next alarm meeting, please.
Okay. Do we have a motion?
I'll make the motion that we postpone electing of officers until our next board meeting.
I'll second.
All right, so we have a motion and a second. If you'll call the roll.
Scott Cockcroft,
Yes, to postpone.
Doug Fraker,
Yes,
Lou Richard.
Aye.
A motion carried to postpone the election of officers for the Alarm Systems Contractors Board to our next meeting. Thank you.
All right, and
Legal report, I believe, is next.
okay.
And this was something I think that we normally do with the elected officers, but did you want to adopt Robert's Rules of Order at this time?
Oh, okay, we can do that. Thank you for bringing. I forgot to do that. All right, Scott, you can get them. We need a motion to adopt the Robert's Rules of Orders to be used during the alarm meeting.
I'll make a motion that we adopt the Robert's Rules of Order for the alarm meeting.
I'll second.
All right, so we have a motion and a second to use Robert's Rules of Order. Would you call the roll?
Scott Cockcroft,
Yes.
Doug Fraker,
Yes,
Lou Richard.
Aye.
Motion carries to adopt the Robert's Rules of Orders for the alarm meeting.
All right.
All right, perfect. So as we now move to the legal report then, you'll see it's kind of there's only 3 new cases and 1 case is being represented, so it's 4 total. But we'll start with the first 3 that are the new cases. So the first one, it's case number 20200762221. Summary is that the complainant signed a contract with the respondent in March 2019 for an alarm monitoring for a term of 5 years. The agreement included the installation of new equipment, and monitoring was for $45.99 per month. On July 21st, 2020, the complainant called the respondent to request service to the alarm system. The complainant stated that she had issues with her front security camera, and the respondent's customer service representative told her the equipment was outdated and needed to be upgraded. The respondent then sent a technician to the complainant's home a few days later. The technician stated that the system's panel and box needed to be replaced. So he removed it and stated that he would be back in a few days later with a new box to install. The technician did not return to the complainant's home as promised, and the complainant called the respondent's customer service representative and left him a message detailing this. On August 27, 2020, the respondent billed the complainant an additional $89 for a total of $134.99. The complainant called the respondent's billing department, and the representative did not have an explanation for the added fee. The representative then sent the complainant back to the original customer service representative's voicemail. The complainant was told a few days later that the additional fee was for the July technician's visit, and that the complainant would have to dispute the charge with the original customer service representative. The complainant has called this individual back and attempted to speak to other representatives as well. However, no one has returned her calls or repaired the issue with the alarm system, so she made this complaint. The respondent responded to the complaint on October 23rd, 2020, by stating it would investigate the complainant's issues, schedule a second service appointment at no cost, and if there were needed repairs, it would fix the issues also at no cost. When we followed up with the parties in November, the respondent still had not addressed the complainant's issues. The respondent stated on December 2nd, 2020, that it would need to upgrade the complainant's system and agreed to do so at no charge. The respondent also stated it would place a monitoring credit of $137.97 on the complainant's account for services not rendered between September 2020 and December 2020. The respondent then sent a technician to the complainant's home on December 3rd, 2020. However, the complainant did not allow the technician to enter the home to access the issues due to her frustrations with the respondent, as well as due to the fact that this visit was unannounced and not scheduled. There are 2 issues with this case. First, the respondent's contract allows for it to charge a $50 service fee for repairs made outside the equipment's warranty. However, the respondent charged the complainant an undisclosed $89 through a direct withdrawal. And 2, the respondent removed the complainant's system box and panel in July 2020, and as of December 2020, had not attempted or actually repaired the system. The service charge issue may be minor overall, and if there was only issue, a letter of warning would likely be appropriate disposition. However, the issue with the lack of repairs is more concerning. The respondent left the system for several months in a non-functioning manner and was in notice of it needing repairs when it received this complaint in September 2020 and agreed to assess the issues in October 2020. The respondent did not send a technician to assess the issues, nor did it make any repairs in October 2020 to bring the system to a functioning level at that time. After we followed up in December 2020, the respondent again agreed to make repairs and credit the complainant for its monitoring cost over the several months due to the lack of received monitoring services. The respondent did attempt to address these issues in December 2020 by sending its technician out unannounced. However, this seems to have added to the complainant's frustrations regarding the necessary repairs. This could constitute misconduct for gross negligence. Pursuant to Tennessee Code Annotated Section 62-32-319D, the respondent's previous letter of warning and consent orders were due to improper statements made by sales representatives. The recommendation is to authorize formal charges with a settlement offer through a consent order and a $1,000 civil penalty for violating Tennessee Code Annotated Section 62-32-319D. Are there any questions?
Where did you come up with the dollar amount for the penalty?
It's the mandatory minimum.
Okay.
Mhm. And I would say I did follow up actually with this complainant again last week, and she had mentioned that she's still being billed by this respondent.
I make a motion to concur with council and level the $1,000 civil penalty in the consent order.
I'll second.
All right, we have a motion and a second. Ms. Vest, will you call the roll?
Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Lou Richard,
Aye.
motion carries.
All right, thank you. Next is number 2, which is complaint number 95941. The summary is this was an anonymous complaint that alleged that the respondent has been installing CCTV cameras without appropriate licensure. The respondent is licensed by the board, however, it only has classifications to perform work on burglary alarm systems. The complaint contained pictures from the respondent's Facebook page in which it showed 1, an individual appearing to install a camera outdoors, and 2, pictures that appeared to be screenshots from cameras in use and allegedly installed by the respondent. The respondent cooperated with our investigation and stated it is in the process of closing its business, but will continue to monitor the burglar alarm systems it is under contract to maintain. The respondent stated it had installed approximately 3 camera systems in 2020 and that those were part of burglar alarm installations. There is an exemption in our licensing statute that allows an alarm system contractor to work outside of its license classification if the work is incidental to the work being performed. However, the installation of cameras and monitoring of alarm systems does not fit within that exemption. Based on this, though, as well as the fact that the respondent has stated it's closing its business, a letter of warning and instruction may be appropriate disposition for this case if there were no further violations, and this could be taken into consideration of any further in violations. So the recommendation for this case is a letter of warning and instruction.
My only concern here is, I'm closing this business. I'm better known as I'm changing my name. That's a big thing anymore is let's just change the name of the company. So I would say we need to watch for the QA.
They are licensed for burglar alarm, right? So, so as far as you have to change the name, it's not like it's somebody that's completely unlicensed. I agree with you. I know what you're saying. Are they really or not? But, it's not like we've had other people where they weren't going to install cameras anymore and they weren't licensed at all.
So Jesse, what's the reason for not doing any kind of monetary penalty since, obviously they've done 3 out of their license category?
I think the fact that they were doing burglar alarms. The main system with all of these was doing a burglar alarm system. And if you look at the pictures of the cameras, we didn't really have a lot of details as to, how intense these systems were, these camera systems were they were installing, but it did seem to be part of an overall burglar alarm system. And I think from speaking with other QAs at times, there seems to be this confusion that if you have a burglar alarm classification, that they think they can then also do cameras if it's part of that. I think they're all looking at that exemption and saying, well, it's part of this burglar alarm system. It's incidental. It's not just a camera system. I think if it was just a camera system, I'd say clearly this is a violation. But since it's part of that overall burglar alarm system, I think it possibly could fit within that exemption. Doing both the monitoring of that and the cameras, and maybe it's doesn't fit squarely within that, but I do think that it's pretty close to that. And the fact that they're going out of business, so I felt like with those two things combined, maybe a letter of warning was appropriate since they did indicate they were no longer going to be installing new systems.
Okay, that makes sense. Thank you.
Yeah, I think there's been some confusion. I think some of that incidental stuff started out originally was about smoke detectors on a burglar alarm, and it's gotten confusing. Which we had someone one time that had a completely separate camera system from an alarm. If these were just like cameras that are like one or two cameras that's added on the alarm, I can understand the gray area. Do we know for sure if it was a complete separate camera system or not, or if it was?
From what I gathered from it, it seemed like, I mean, they didn't give us, the contracts or anything like that. We did ask for information, but they basically just said, we're going out of business. This is our statement. So no, we didn't really get good corroborating evidence on that. We're going off of their statement with that. But from looking at the pictures on the Facebook page, it would make sense that that could be connected to that.
Okay.
Mm-hmm.
Well, do we have a motion?
I'll make the motion to concur with council and send a letter of warning.
And I can second as the chair.
Yes, you can vote.
Okay. Well, so I would second. So Ms. Vest, so we have a motion and a second. Ms. Vest, will you call the roll?
Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Lou Richard.
Nay.
All right, the motion carries 2-1. Lou, that was a no, was it not?
Correct. Yes, that was no.
All right. Let the record show that the motion was made and seconded and carried with 2 yeses and 1 no. Thank you.
All right, thank you. So we'll move on to number 3, which is case number 20200971161. The summary is that the complainant signed an agreement for an alarm system and monitoring services by the respondent in October 2018. The contract was for a 3-year term for $59.99 per month. Over the past 2 years, the complainant has had issues with the doorbell camera installed by the respondent, and the respondent has sent technicians to repair the issues. The complainant stated the respondent has had packages tampered with on his front porch that the doorbell camera should have caught, and that the doorbell camera is no longer working. The complainant requested a full refund of all money paid to the respondent over the past 2 years and for the contract to be canceled. The respondent agreed to cancel the contract without penalty to allow the complainant to keep the equipment at his home and refund the portion of the complainant's payments that were going towards video services of $10 per month for 26 months, and the complainant was while he was under contract. There was no indication that other equipment was not performing correctly or that the complainant was not receiving monitoring services for the rest of his equipment. The recommendation is to close.
I'll make a motion to concur with council and close.
I'll second.
All right, we have a motion and a second to concur with council. Will you call the roll?
Scott Cockcroft,
Yes.
Doug Fraker,
There it goes. Yes.
Lou Richard.
Nay.
Motion carries.
All right, thank you. This is the last case in the legal report. This actually is a case that's represented from the last legal report. This is case number 2020054971. Previously, the board had voted to do a $5,000 total civil penalty for multiple violations, and I'll explain in some of the new information as to how that's addressed. So without reading all of that previously, I'll go to the new information. If we have any other questions, we can go back to that. But the new information that we received through negotiating settlement of this matter, the respondent has provided additional documentation to the board, which included copies of the contracts that were electronically signed and additional videos of the complainant being disclosed the terms of the contract and agreeing to them. Additionally, the respondent provided a customer care log in which the complainant had called the respondent to cancel the contract and alleged the respondent had fraudulently added his sister to the account. The customer care representative appeared to ask the complainant if he signed the contract for his sister, and the complainant alleged that the complainant allegedly did not answer the question. This documentation does not appear to dispute the allegations of fraud, or sorry, this documentation does appear to dispute the allegations of fraud purported by the complainant. The respondent did not dispute that its employee was not properly registered at the time he contacted the complainant, but the respondent did provide further documentation where this employee applied for registration in March 2019. From our records, though, this employee's registration was denied less than a month later due to a material misstatement and told to reapply online. As stated above, this employee reapplied for registration in July 2020, and his application was granted in August 2020. The respondent has also agreed to cancel the complainant's contract and refunded all payments made to the respondent. Based on the respondent's supplemental documentation, it would be appropriate to settle this matter with only the violation for the unregistered employee. The other issues regarding the allegations of fraud are rebutted by the supplemental information, and if there was a formal hearing, it would be the complainant's word against the respondent's documentation. Additionally, as the complainant has been refunded his payments and his contract was canceled as requested, it appears that these issues have been remedied to the extent possible. The respondent has had several letters of warning previously, but due to the size of the respondent's business, that's more of a reflection on the volume of clients rather than consistent ongoing violations. So the recommendation is to instead authorize formal charges, but the settlement offer through a consent order and a $1,000 total civil penalty for having the unregistered employee with access to sensitive information pursuant to Tennessee Code Annotated Section 6232.312 and Code 6232.304K. So essentially, we would not be putting language in the consent order or finding violations for the fraud or the standards of conduct issues.
Do we have any discussion, or do we have a motion?
I was just looking back over the original complaint. So it started out the whole, your system is due an upgrade.
Mm-hmm. And that,
whether you're a registered employee or not, that's still wrong.
mm-hmm.
They do have a lot of documentation or a lot of stuff to back up that he knew that wasn't the case. I mean, I guess
Right.
they could have started the whole thing that way. It's one person's word against another. It also could be made up.
Mm-hmm. I agree, Mr. Cockroth. I think that the issue, there was a concern when we initially went through this. The documentation that we received was not as in depth as when we received from after we sent the consent order. And initially, it did seem like a situation where, okay, well, maybe these statements were made. This complainant could be credible. But then when you start to look at and you see these videos where he's being disclosed that, we're not affiliated with this company and things to that effect, it starts to get harder to prove.
And they are actually, I noticed you said videos in the paperwork, but they are actually videos, not audio recordings.
They're actual videos. So you could see the complainant's face and he has a little button, I think it's like an iPad or something, and he clicks yes or no. It looks like with his finger with some type of pointer on it.
Of course, the issue of it was supposed to be his sister that was signing it. If there seems like there was something going on there with the sales rep. If it's supposed to be his sister that's signing it, and he did all the paperwork.
Right. And there was no video of the sister signing to these agreements, so that was concerning. That was something I noticed as well. It could be a situation where the complainant had signed for his sister. Initially, the complainant said, "I didn't sign anything. That's not my signature. That's not my sister's signature." And now it's from some of the additional paperwork we received. It may be a situation where he signed for himself and his sister. I will add that. Oh, sorry. Go on.
I was just going to say, so the outcome for the customer at this point is that they have canceled everything.
Yes, that's my understanding. I will add that $1,000 penalty from the bottom that I had mentioned, that was just the statutory minimum that I had recommended. So if the board did feel like there were other circumstances, it could be a situation where the board wanted to go above that. That would be appropriate if the board believed so.
Do you have any other questions, or anybody have a motion? Personally, I'm inclined to go along with council as far as I think there should be some penalty. I don't think it's clear um, as far as the fraudulent stuff. Sounds like there was some error on both sides, or some deception going on.
And I think, as I mentioned in the when this case was initially presented, there's the complainant is an older gentleman, so there are some concerns, I think, potentially about his what he actually knew or understood. Shortly after our investigator initially contacted him, he had contracted with a third alarm company. I think that was mentioned in the top. And it was another company that had come in and told him that, we can give you a camera outdoors to do cover where these cameras aren't, or provide something else. And he was even contracting for, the smartphone capabilities to be able to check and review your cameras. And he doesn't have a smartphone. So I think there are some issues with maybe what he actually understands. I mean, from the documentation that was provided by the respondent, though, it does appear that they did try to explain everything. There are these videos where, he's saying, yes, I understand. Yes, I understand the terms. I don't know how much he, in
There,
fact, understands.
yeah, there is something there ethically. If they had some concerns, or if it was pretty obvious whether or not they should have even moved forward, if they kind of felt like he didn't understand. I mean, selling something for a smartphone that someone doesn't even have one.
Right. And that wasn't the respondent. That was a third company. I just used that as an example, though, to show potentially his limitations, because that was something that our investigator had called me immediately about, because he was concerned about as well.
I look into I know that it's a large company, but they do have discipline history. Do we know if that history is any way related to what happened in this case?
It is related to having unregistered employees. So similar to this in that regard, but when I went back through, it was not a situation with fraud or anything like that.
Okay.
Then we have it's more solid on the employee side of things. That's undisputed.
Well, and that would be for the, the settlement offer of the violation as well. If it was a situation where we had to have formal charges on it, normally we do kind of throw everything out there just for consideration as well. So if for some reason it wasn't agreed to and we had a formal hearing, those facts could be considered by the board as well. But I agree, though. I think for looking at the actual violations, I think that one is clear. We can look at the dates when he was registered, look at the dates of the contract. We do know we have that violation. The other ones are much less clear as to whose word is more persuasive.
Could we look at the employee side of thing as multiple violations for a larger fine? Because they not only ignored the fact that he was denied for material misstatement, and then they continued to work him as well, unregistered. It was like they didn't stop working him, and then they.
Well, I don't think he was. That may have been not clear by me. I don't believe he was actually working for this company in between that period. I think when he had initially applied in March 2019, either he was affiliated with another company or was not with this company.
Okay, so he had been denied with another company. Then he went to work for this company, and they didn't even try to register him until after this.
Mm-hmm. Until at least after he was in the field. So the statute does say, a minimum penalty of $1,000, maximum of $5,000 per occurrence. So the board, does have, if some of these circumstances warrant going above that minimum, I think there are justification to do so. If you wanted to do something closer to $3,000, $4,000, but there would be a maximum statutory cap of $5,000 for this violation.
Well, there's obviously a history of this violation, so I would, I would suggest that we, bring the minimum up to at least 3,000. My opinion.
Do you want to make that a motion?
We can make a motion to make a motion to raise the minimum or the penalty to $3,000.
I'll second. We have a motion and a second to raise the penalty to $3,000 on the employee unregistered. Ms. Vest, would you call the roll?
Yes, Scott Cockcroft,
Yes.
Doug Breaker,
Yes.
Lou Richard.
Aye.
Motion's carried to change the civil penalty from $1,000 to $3,000.
All right, thank you. And that was the
Carries.
last case from the legal report.
All right, and then next we have appearances.
I don't believe we have any appearances today.
Okay.
So if it's okay with you, I'll just go right into my little portion here of the administrative matters.
Okay.
And the first thing is the monthly report. The only thing I really have to report right now is you still have one vacancy. I have turned that into administration on that, and they're working on it. You do see where we've had a meeting with the attorney and a monthly financial meeting. So unless you have any questions about that, I'll just move on because that's pretty normal there. If you'd like, we'll take a look at the budget. I am pleased to say your ending budget as of December, this is the last one I've gotten now, is $74,332. I didn't see anything out of the ordinary there, so that's moving smoothly as far as the budget's concerned. If you look at the next thing, it's going to be your legislative updates. It has been my understanding that the association has sent a bill up to extend the sunset for a year, which would give them time to do whatever it is that they wish to do to make changes.
Cody,
I have
were we sent a copy of that? I don't see that
no,
in the attachment.
no, you were not. That's
Okay.
I don't have that myself.
All right.
I'd have to get with the association, find out what the number is to pull the bill. I just know that they had told me that they had done it. Penny Brooks did.
I think I have a copy of that if you'd like me to give
Oh,
that
okay.
the number.
What's the number? Okay.
That would be Senate Bill 0690.
0690.
Mm-hmm. That's the bill that extends sunset to June 30th, 2022.
All right.
But there's not a corresponding House bill for it. It's just a Senate bill at this time.
That means right now it's not moving. It has to have a Senate and
Right.
have to have a House for a bill to even move in the committees, from what I understand.
Mm-hmm.
The only other thing is the merger bill. Jesse, you want to address that a little bit?
Sure. So there was a bill that was introduced, and I can give you the numbers for that as well. That would be House Bill 0781 and Senate Bill 0770. Both of these bills have substantial changes to a number of areas of law. So if you do look it up, you'll notice that there's other regulatory bodies. So maybe some of this confusing, but a couple of the things that it does is it changes the definition of what an alarm system is. And then it also would merge the board into a commissioner-run program and create an advisory board. Those are basically the main highlights as it affects this program.
What they were attempting to do is to take all the four of the programs that is under me as the executive director and merge them together. In order to do that, of course, going to have to do that bill, but that simply states that there would be 3 alarm employees. There'd be for the commissioner run program, 3 PIs, 3 PPS, whether it be companies or whomever, 1 polygraph and 1 public. So there'd be an 11-member board instead of just you'd be separate. It's going to combine all the expenses together. I don't have to move employee from here to there to figure out how they're going to get paid out of one program or not. You probably know, as I've talked to you, some of the programs have a difficulty with fees. That's why I said I was really glad to see the total that we have on alarms, but I'm not supposed to be carrying over a large amount either. And I still don't know anything about the reserves, which now are holding at 2,384,716. That would merge all the monies for all 4 of my programs together. Just when you look at it, you'll see 62, 32, 62, 26, 27, 35. Those are our programs, but there are other ones also in this merger bill.
There's several programs, but it would as Director Vest stated, it would merge those under her as a commission-run program. It would also, so it's something else I pulled up my notes on it. It would also lower some of the educational requirements for qualified agents for alarm system contractors. Currently, as I'm sure you're aware, there's education and experience requirements, and this essentially would kind of create more flexibility with certifications that could be considered for experience. And then just looking at my notes real fast, and it would also change the penalties for alarm system contractor violations by removing the mandatory minimum and giving more flexibility in enforcement of civil penalties.
Okay, we don't have any questions on that. We'll just move right on to requests for extensions, and I don't have any. No one's requested an extension. So we'll go straight into the criminal history. I had 2 of them, but after reviewing and receiving some documents, I was able to approve one due to the diversion he had received. So I took him off. The one that you're going to look at is Brian Stringer. He is going to be exhibit, should be your criminal history review exhibit B. Let me know when you get there, and I'll tell you a little something about it. It's very lengthy, and I've broken it down a little bit. We do have his letter of explanation. You might want to read that. We do have court documents. There's a lot of court documents. This charge is over 10 years old, and it's for possession of stolen mail. This was back in 2005. He got 10 months with a year's supervised probation. Then he violated probation in 2007 and 2008. So he got an additional 8 months and 11 months. But like I said, that is over. I'm sorry, I had something come in from the legislative committee there. So if you want to, let me see. He's with a out-of-state company. He would be an alarm technician. You don't, like I say, you've got a lot of court documents there to review, but you may want to move on down to his actual written explanation. It's a little lengthy as well. So it's right, should be one of the first things that you have there is his explanation. It's several pages long, so I'll give you opportunity to look at that.
We had it ahead of time. I don't know. We may have. I had a chance to read it ahead of time.
Oh, okay. Okay, good.
Do we? And we don't have any other letters of recommendation or anything. We just have his letter of explanation.
Yes, so we don't get those letters from the qualifying agents anymore. Like I said, this is a huge company out of Texas. No, I'm sorry, it's out of Utah.
Do we?
I have had, excuse me, I've had contact with the company asking me if I was going to approve his application, so they know about it.
Okay. And I know it showed restitution. Did he make restitution on all of this already?
That I really don't. I saw it was 4,000, little over, pretty close to $5,000. It
Right.
was so long ago. No, sir, I don't know if he's actually made all the restitution, but since 2005.
Because technically
I
he'd
don't know.
be on probation, wouldn't he, if he hadn't? That was my only.
Uh-huh.
I couldn't tell from the document.
Not showing. There's a lot of it to review, wasn't it, Scott? I mean, and it's it kind of repeats itself when you look at the documents with their co-defenders and everything. But like I said, I would have to take this to the Fresh Start Act. I came up with just a little over 10 years ago after reviewing it.
And I wondered about that. I wasn't entirely sure from some of the dates. I mean, 10 years as far as when all of the probation, criminal charges, everything were
Right.
over.
But no, actually, yes, sir, because if you did it the other way, if you took it from 2005, that's going to be 15 years ago. So I looked at the probation.
Okay. Any discussion or any thoughts?
This is a lot. And I looked at it earlier before the meeting too.
Yeah.
It's just hard to just boil it down to what exactly happened here. I mean, we've got mail theft, we've got repeated drug offenses, I can tell, from what I can tell. Was there anything else that I missed?
No, but now say he puts a lot in his written explanation, and the only thing that's on his TBI and FBI background is the mail, stolen mail. Now the other charges he's talking about, as far as his drugs or whatever, there is no record of it on the FBI report. He was supposedly honest enough to tell us about it, but if we're looking at denying him, we will have to take him to the Fresh Start Act. Apply him to the Fresh Start Act. And it has been a substantial amount of time. Looks like he's tried to turn his life around. He's got a family now. He's with a large company. They are aware of the charge and conviction. He's still employed with them. So we'd have to name which of the, if we're looking at to denying it, we'll have to say what numbers we're denying under the Fresh Start Act.
And Cody, I think just for clarification as well, we look at the Fresh Start Act. It says the amount of time that's passed since the commission of the crime versus, when it was all resolved. So I think we'd be looking at that 15 years since that mail thread for when it happened.
Right.
Just for clarification. But if you want, I can go ahead and read the Fresh Start Act into the record if we're looking at denying him, just so we can start talking about factors. But if you all are leaning towards approving him, then we wouldn't need to consider the Fresh Start Act at that point.
Even with you would go back to the original time, even with all the probation violation things, because it relates to the original crime?
Well, technically, that's a good question. The way the Fresh Start Act is from the commission of the crime, the amount of time since the commission. So, we could look at each probation violation as a commission of that specific crime would be, a violation of probation. But for the actual mail fraud issue or stealing mail issue, that would be the amount of time since that occurred would be under the Fresh Start Act. The violations of probation would be the amount of time since those occurred. So I'm not sure, and I'd have to look back at his explanation. I can't remember if he said how he had violated probation each time. I think there were some drug issues at some point, but those would be considered based on the amount of time, or from when those were committed to today. So I think we're still looking, though, at over 10 years, because I think he had finished probation 10 years ago.
Okay. And I'd like to give him the benefit of the doubt. But all we have is his explanation. I mean, by his explanation, he has had a tough life, but there's two sides to every story. The mail fraud, I guess, is probably for me the more concerning, because I thought that he was going to be in sales, which if someone's doing fraudulent things with documents and stealing stuff, they'd be willing to do that with alarm agreements too. But nonetheless, he'd be in somebody's house. And the potential to steal credit cards and things. I don't know the person. I mean, to read what he says, you'd like to believe him and say that he's turned things around, but all we have is his word for that. What are your thoughts?
I'd like to, so reading his statement, it says that he left an oil industry job in 2012, but I wonder what's happened since 2012 until 2021. That's my only concern, is what's happened in those years. Has he held jobs? Is he, that's my concern.
Do we want to ask him to appear?
I would feel better if we, heard from him directly. There's just too many blanks here that I'm concerned about.
That makes sense. So do we need a motion to do that, to request?
I would think we would, wouldn't we, Jesse? Under the circumstances.
I would say it would be a motion to defer this until the next meeting and when he can come in for an interview. That's how I would phrase it.
Okay. Would you like to make that a motion?
I'll make the motion to defer this till the next meeting and an appearance.
Okay, and I'll second. So we have a motion and a second. Ms. Best.
Lou, okay,
call the
Lou
roll.
and Scott. Okay, let me write that down. Lou and Scott. Okay. Scott Cockcroft,
Yes.
Doug Fraker,
Aye.
Lou Richard.
Aye.
The motion carries to defer this decision to our next meeting to give the gentleman an opportunity to appear.
All right.
And we will send him the letter and we'll make the correspondence with him and everything. All right, good. So that's all I had for the criminal history. Didn't really have any education review. Everything that was sent in is already on the course list and I've already been approved. So if it's okay, I wanted to go down to unfinished business. I wanted, and I think I already told you, but I wanted to make sure I put it on the record. There was some discussion at the last meeting about a company by the name of Turnkey Technology. Well, they thought they was going to fall under the exemption. They did not. They have since been licensed. They did get a qualifying agent. That was their problem. And get to give the gentleman that we had talked about opportunity to attempt to get his QA license, but they have a licensed qualifying agent now. The other one that we talked about was a lady, Qiana Van Horn. Remember, she was going to be a registered employee for her husband's company.
Right.
You had a question that was, once we issued the registered employee license, she'd be able to go out into the industry and work or whatever. You asked for a statement from the company, the qualifying agent, which I did receive, that said no, that she would be in the office only, that she would not have an opportunity at all to go out to do any type of sales, or she's just going to be doing office work. Those are two things that you wanted me to make sure that we did, and I wanted to follow up on it with it. I think right now we can probably go into new business, and it's a little different. The first one here is from PSI. We had a gentleman who wanted to take the qualifying agent exam, I believe in Oklahoma. He went and purchased the new books, or NFPA, I believe it is. The new books, and they didn't want to allow him to take the exam using those books because that's not what's in the brochure, the bulletin that PSI sends out. So I've had some correspondence with PSI. You have it there. He wanted to follow up with me, and he said they will allow the gentleman to use the new edition of the books if the commission approved it. And he suggested that we make a change to the, they call it the CIB, the bulletin, so all the offices will know that that's acceptable. And then he did ask, secondly, if we have the ability to update the exam items in the CIB to reflect the newer NFPA standards, and has Tennessee adopted any newer NFPA standards since the 21-22 edition? He'd like to schedule an exam review with our subject matter experts, and that's from PSI. So we're asking, can the gentleman out of Oklahoma, that's in Oklahoma, take the test with the new materials? And I believe we have somebody, well, let's go ahead and discuss this one first.
And especially if it's out of print, I would think that we should allow them to use the newer version. And it sounds like the test should be updated to match it. There are different jurisdictions that use different versions.
Okay. I believe this is the first person that I know that has even asked about this. I have not received any telephone calls from PSI. I haven't received any correspondence that I'm aware of from anyone saying that they were having trouble with these materials. But it's outdated, yes, we do need to look at it. We can set up a time. Now, this is time consuming to do this. To do and call together subject matter experts, but I can pull this together probably in a few months before we could meet or whatever. To go, but what he was talking about is going over the exam questions, not the exam material. So I think if we're saying yes, you can use the latest books, the latest material, we need to go ahead and get that added to the CIB and let him notify all his offices that yes, it's proper for them to use those books.
Well, because he was saying he couldn't even get it. I think he was saying that whatever whatever code, which I don't doubt that there's probably jurisdictions using something even older than that. It can't. Some of those can be found. That's probably why people haven't complained. But of course, people do definitely complain about the exams not necessarily matching the real world.
Yeah. Oh yeah, the exam itself. Yes.
Yeah.
Not the materials that we have chosen. Yeah, he has his it's Brent Hicks, so I'll go into he did have his correspondence in there on page 4 about taking the exam in Oklahoma City. He tried to take it and he bought a new version, the NEC book that was listed on the bulletin. He called someone here at our office and he was told that he could use it. I think he might have called the center because no one in our office would have told him that and without talking with me about it. So this is the first time I heard about it too. But that's from PSI. So my question to the board is, can I tell PSI, yes, the individuals may use the newer edition of the books if it helps them, because the test is based on the old information, I thought. I mean, but if it would help them, I don't see any reason why they could not take it in. But I'd have to have a vote from the board, and then I will get back with Mr. Ham and tell him to please add it to the brochures until we can get to the point to where we review the exams, if that's okay with the board.
Yeah, my only concern would be is if they use a newer version and
they fail
and it hinders them.
Yeah.
Uh,
Then what happens?
Right. And
That's kind of what
any of the board members have seen the test because it was all done before we were board members. So.
Oh, okay. So it's been around a while. Probably does need to be redone. I have to look at the contract. I believe it'd be okay because we went. Remember, it was $5,000 for each exam. You had 4 exams. And we went into the new contract, and it should read. I'll have to look at it, but it should read that they would do this at no fee. First time you review your exams is at no cost due to in the contract.
And
it's
this
just getting it all together.
If this is related to the NFPA, would be about the fire. Should only be related to the fire test, I would think.
Well, do y'all know of anything that has changed? I mean, is there new codes from the fire? I think that's what they're asking. That is something that I do not know.
I'm sure there's things that have changed in the code. I mean, I don't know off the top of my head as far as what changed from one to the other, but I'm sure there's things. And there may not even be a single question on the test that relates to something that changed, but not knowing what's on the test.
I was gonna say, I just looked. My book is a 2011 because it's not something you look at every day. But whether it's a 2011 versus 2017, like you said earlier, Scott, if the information has changed that much, then we've definitely got to update our tests.
And I mean, we don't know what's on the test. I mean, may only be one question about that on there or something.
Well, my only concern is I don't really have a concern. They can use the old material or they can use the new material. But if there's questions on the exam from the old material and you only studied the new material and you fail, what liability is going to be for us?
Right. That's why I would think I mean, we could let them use it with that. I don't know if that caveat, but it definitely sounds like we need to review the courses. I don't know when were they last reviewed.
Well, we went into this new contract last year, I believe it was. Before that, it was a 5-year contract. Then we had an extension, maybe 8, 9 years ago, maybe even 10,
Of when they actually, because
when we sat down and wrote these. Yes,
wrote it. Yeah.
it has been a while. It is due. It's probably overdue.
So can I call on somebody that's on our webinar and ask a question?
Yes, I believe we did have someone who wanted to speak, I believe, about this.
Hey, Roy, are you listening right now?
I am, Doug.
You're the guru of laws and rules and all that good stuff. Do you know anything specifically between 2017 and 2011 that we should be concerned about?
There have been hundreds of changes to both documents, NEC 70 and NFPA 72, the fire alarm code, since the 2010 edition. Now, I would not know what was changed on the exam, but there have been significant changes and things added and altered to coincide with new technology, new codes and standards, and new practices.
Which could give you wrong information when you're filling out an answer on the test. Well, my opinion is we could tell this gentleman, I would almost want to say, let's make an exception to let this gentleman take a test with the 2017. And then we get on to reviewing to update the test to be 2017 instead of 2011. But I don't know if we can do that just for this one time, let this guy take the test.
I think we'd have a harder time with PSI doing that. But hasn't he already taken the test? Did he not pass? Or I thought the issue was he was taking the test and ran into the problem.
That I really don't know if I can tell you that or not. He does say, I was trying to get to his correspondence here, where he said, when I took my Tennessee burglar alarm system qualifying agent exam on October the 30th, 2018. So I don't even know what the man's issue is. If he took it in 18, I bought a new version of the NES than the book listed on PSI exam. Then he called and they said it's okay for him to use it. Here he says up to the top, I'm scheduled to take 2 of the qualifying agent exams for Tennessee in closed circuit television and the Tennessee fire alarm. So he's taken additional classifications. And then when he went to the center to take the book in, and when he took the book in, he took the newer edition in, from what I understand. They're going, oh no, that's not what's on that's not what's on our brochure. You're not allowed to do that. He said they're not in, they're 11, he's researched these, and the 2 exams are, the above reference material of these 2 exams are old as 11 years, are not in print or available as new copies. I have searched the manufacturer's website. So he's saying he's not able to even get the material, the old material.
Right. Yeah, I saw that on there, and I understood that part. And but the concern would be that if he doesn't have the reference material the test was made on, that it may be worthless to him. It may be worse. having new reference material that doesn't match the test, he might find the exact reference and think he's 100% sure, and he'd been better just guessing. So that's my concern. But I don't know how we remedy it short term. I mean, I'm fine personally. I would be fine with him using it, but it may not be accurate. I do think you can find the book, but it may not be in print, and that doesn't seem fair. I can understand why someone taking the test is like, goodness gracious, I can't even buy the stuff for the test if they go to buy new books.
Okay. Roy, do you know if this material is still in print? Or where I would send this gentleman to get this material?
For the
Book?
fire codes and the electrical codes, you go to nfpa.org and you can buy past versions. You can buy the 2010 version online on their website.
Can you give that to me again? nfp.org?
Nancy, Frank, Peter,
Oh,
apple.org.
oh.
I just punched it into Amazon. You can buy it on Amazon.
Well, according to this gentleman, he's having a whole lot of trouble buying it.
They say they got two. Tell him
All
call me.
right.
I'll sell him a copy.
Maybe I need to. No, you won't.
No, I'm kidding. I'm kidding.
Maybe I need to call this gentleman myself and tell him we just saw it on Amazon, or you can go to where where Roy said.
I wouldn't recommend he goes on Amazon because if they're not new, they could be noted up. There could be notes in them, and they're gonna
Oh.
as they come in. They're gonna look through everything, and if they see markups, they're not gonna let it in.
Oh, I didn't realize that. Okay.
So
Well,
he
I'll
can
give
go
him
right
the
through.
website then that he can go to.
Yep.
Just let me. I'll call him if that's what. The question for the I have to finish up on with the PSI is are we going to let people take new materials in? I understand. Or do we want to just address it one at a time? If a complaint comes in, I haven't been able to find the material, to go ahead and change your PSI bulletin that says you can take in new material. That may put us liable if they're not able to pass the exam. I don't know, Jesse. I mean, I don't know
Well,
where we
I
stand
don't
there.
like the idea of us saying 2017 is okay to take in there until we can compare the test. You know, it's been years since I've seen one of the tests.
I agree with that. I would say just keep with the 2010 version. I mean, if they want to allow him to take that, you know, I think we could give a disclaimer and say that, you know, you can use 2017, but this test is not based on that material. But I mean, it sounds like we probably need to have that test reevaluated to see if it's even, you know, if it still has correct law on it. I mean, if it's got previous versions that are no longer applicable, those probably need to be removed and updated.
Okay.
I think Roy's got some questions
Roy,
on the QA monitoring exam.
okay.
The monitoring for the QA. Roy, can you give your input on that?
Well, my comment, I did want to speak to the board almost on the same topic, if you don't mind. On the PSI bulletin, which is the most recent that I downloaded, dated August 31st of 2018, references a standard, which is the standard for remote supervising station 2007. That's an ESA standard that was created 13 years ago, and it was adopted as an ANSI standard, but that was not renewed more than 10 years ago due to the cost and the lack of acceptance of the standard. That document is not available on the reference website that PSI has in their bulletin, nor is it available with a Google search as Mr. Fraker just did on Amazon or anywhere else. That standard is no longer valid. It's not, it doesn't simply exist. I have a draft copy because I worked on the standard back in 2006 that, but that's not even the final approved version. And I want to address the board to ask that that be updated with PSI and that reference be removed totally from PSI's bulletin and from any questions that might be related to it on the exam, since nobody can get that standard. And I have reached out to the ESA Standards Committee Chairman, who also himself does not have a copy of the completed and final version of the standard. And like I said, the only thing I have is the draft, which is not necessarily the final. And so that would be my ask of the board, is to address that and probably have that removed from their bulletin and any questions that might have been arise from it.
Okay, with Roy with us, going to take a look at the test questions and make the changes with PSI as needed. Can we do that? Would that answer your question, your concerns? Instead of us trying to change the just tell them to take something out of the brochure right now. We can do it all at one time.
Yeah, only, I'm sure that it's going to take some time for you to change your policy and change PSI. I have a gentleman that's going to be taking the exam. I gave him my draft copy, which is probably as close to final as it's going to be. But I'm thinking for others and in fairness that really nobody is going to be able to locate this document since it no longer exists. And it's not a valid document. It's been dropped by ANSI. It's been dropped by ESA.
Well, do you know if there's a question on the exam?
I do not,
I don't either.
unfortunately.
No, whenever we took a look at these exams, or we do any of the exams, the only part I have anything to do with is the laws and the rule. It's broken out into two parts: laws and the rules, and then the electrical part or the alarm part. And that's where your board members and your experts discuss what's going to be on the exam and do the exam question. So I honestly haven't seen them either on the second side, only on the laws and rules side. Have you heard of anybody having these particular problems on this exam, board members, that Roy has mentioned?
I haven't directly on that particular standard.
Excuse me.
But I'm sure it's an issue. I mean, I've heard other
Don't doubt it.
concerns that it sounds like the tests definitely need to be updated.
Okay, Roy, with that take care of your question there. You gave the gentleman the material that you've got. Would you get back with that gentleman and find out if there was any questions on the exam that he needed to use that material? And then we can take a look at it, get back with us, and then we can get with PSI at that time. Would that be acceptable?
Yeah, as soon as he finishes the exam, I'll ask him to report back to me and let you know what happened. But like I said, this is 13, 14-year-old standard that doesn't exist anymore. So I don't know who creates the exam, but I think the board should be advising them that this needs to be, one of the references needs to be removed and altered from the testing.
Okay, well, how about, if you don't mind, send me an email to that effect. If you don't mind, with the name and everything that we needed there. We'll take another look at that. All right. Then we would get together with our board members and what they call experts in the field. I will have to make recommendations for these names and everything to do. We just have to get through the other month of February, maybe the beginning of March, with other legislation that's going on, because it's going to be time consuming, people. We'll probably have more than one meeting. We'll probably be doing this virtual. Last one we did, I think, Roy, you might have been there. I don't know. We went to a hotel in Brentwood. That's the last time I can remember reviewing these exams. And we reviewed all our exams. We had alarm people sitting at one table, PIs at one table, security personnel at one table. It was very intense. Good.
I don't know if it's permitted, but I'll volunteer to be an SME to assist you on the review.
I appreciate that, Roy. We'll be asking, I'll be coming back and asking our board members to submit names for experts, excuse me. All right, if that's okay, well, I think I've left it at, I'm going to talk with PSI. I'm not going to make any changes right now. I'm going to call this gentleman, make the reference to let him know we think the book can be found. Explain if he used the new test material, it may not help him. It could hinder him a lot on that exam. And then I will talk with Mr. Ham with PSI to try to at least get a date scheduled for us to meet to talk about reviewing these exams, starting to get it moving, if that's okay with the board members.
That sounds
Have
good.
any- All right, we will move forward on that.
I've just got one question for Roy before we move on. Roy, is
Okay.
your test taker hoping to take that draft document into the exam?
Ooh.
I've given it to him. I don't know that it says draft on it, so he had to print it out because it's a PDF. We'll see what happens when he gets there and takes the exam, and I'll let you know.
Okay. Thanks.
All right. I think we've answered that. Now we're going to go to new business. It should be new business exhibit B. This is a company called Network Infrastructure. 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 Sorry, it kind of hung on my tongue there. They want to know if they need to have a license. So if you go to, let me help you get through this. Go to page 6. It's numbered as page 6. And that's where the email chain starts, with him asking the question and telling you about his company. Now you've got this in advance too, so I'm sure you've probably already read it as well. This is another company saying that they're not an alarm company. All they do is hook up cameras.
Right, which he does go on to say he installs, and in my opinion, he needs a license. He goes back to monitoring or something, but it's the installation and cabling and all that that gets him, where he needs to have a license. He could sell the cameras at his retail store over the counter, but when he runs a cable for it or puts them in my opinion, he needs a license.
Okay, that's his questions on page 6. We had already told him, and then the staff office, that he needed a license. Well, then he came back, and if you would read page 3 was what he came back with. Trying to fall under the exclusion.
Which I don't see how either of those. It says they do not actually sell, install, or service. Well, he sells, installs, and services. And then B is it's officers wouldn't have access to sensitive information. If he installs them and services them, he knows where they are and where the wires are run. And I don't see how either one of those is an exclusion for him.
Well, and here's a kicker. When you look up the website, his company website, it gives a business address. You punch in the computer the business address. It's the United States Post Office.
What?
Yeah.
Oh, okay, yeah.
So his business address is a post office.
A PO box or something.
Yeah, it's a PO box. Well, he's got a PO box, but then it says he's at 11409 Municipal Center Drive. So he don't have a retail operation. He's using a post office box.
But even if he does, that's something that I understand what you're saying, but it's just so that he doesn't get caught up in that.
Right.
Even if he has a retail store, assuming he does, it still doesn't exclude him. He does in itself, but even if he doesn't, it still doesn't. Do we need a motion for anything?
The facts are he designs, he sells, and he services and installs. So,
Right.
Yes, sir. I'll need a motion. Like I said, the office, we've already told him he needed a license. He says no. So of course I gave him the opportunity to come before the board with the material that he gave us. He would still can appeal your decision to come before you and talk to you if he wishes. But I will need a motion to either say he needs a license or he does not need a license from the board, please.
I'll make a motion that he does need to get a license for CCTV.
I'll second that motion.
All right, we have a motion and a second. Ms. Vest, would you call the roll?
Okay, so that was Doug that made the motion, and it was seconded by Lou.
That's correct.
All right. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Lou Richard.
Aye.
Motion carries that this company will need a license, and we will let them know that.
All right.
All right.
Does that,
And actually, that might be kind of mute too, wouldn't it, Jesse? If I send, don't we have some legislation to remove that CCTV classification?
I think under that merger bill, it does merge it, but the definition of the alarm system still potentially includes cameras. So we'll have
So
to
he would,
look at how that all, how that all works, because potentially it might move that as a classification, but if you're installing a camera, could it still fall under a burglar system? Could it still fall under, yeah, I think, I mean, that's where it's going to be confusing, the way that that bill changes the definition.
well, the definitions definitely need to be updated. People get caught up in the CCTV description that there's no more closed circuit television, but
Exactly.
still video surveillance, it's CCTV has come to mean something much more broad than just the piece of coax connecting a camera and a monitor.
Right. I agree. So I think it depends on exactly what type of cameras he's installing. I think they could still fall under the definition of an alarm system potentially, based on what he's doing. And this is a strange one too. I don't know why he wouldn't, he could go get an electrical license or something else, try to fit under he's installing. I agree. I think Lou Richard had mentioned it. Everything he's doing is going to fall under the definition of an alarm system contractor. So, Cody, do you want to open a complaint as well, or do you just want to have him appear at the next meeting?
no, I don't. That's up to the board if they want to open a complaint, but I believe we need to give the man an opportunity here since he has asked us. I will go back to him and tell him he needs to get a license with what the board voted. If
Okay.
and give him the option, I said he could come into the next board meeting, explain to you exactly what he does, how he does it, or whatever presentation he wants to give to see if it'd make a difference. But other than that, he needs to get a license.
I agree. I wasn't sure if opening the complaint would move that part faster if we have to head towards a hearing on this one.
Well, let's give the man an opportunity first.
Okay.
Because he came to us, right?
Yes.
Yes, I definitely
He
think
asked us.
should give him the benefit of the doubt on that.
Okay.
Yeah, that's good. Well, actually, that's all I have, Mr. Chairman.
All right. So
I need a motion to adjourn.
Before we adjourn, I've got just a quick general question on.
Oh, Luke. Okay.
Yeah, on when we approve a CU course, is there a requirement by the provider that they renew every so often?
Yes, sir, I believe they're all supposed to renew, aren't they, Shauna? I thought she was still with us. Give her a moment to yes, they're supposed to. I don't know. I don't remember exactly the date, but they're supposed to renew.
Okay.
Yes.
Okay, I didn't know that.
They can renew.
The renewals don't come before the board. So
no, I mean if you
question. Okay.
If it's still the same information, we just go ahead and approve it for
Gotcha.
the renewal.
Okay. All right. Thanks.
Okay. All right, Mr. Chairman, are you ready to adjourn? I need a motion, please.
do we have a motion to adjourn?
Make a motion to adjourn.
I'll second.
I have a motion and a second. Ms. Vest, will you call the roll?
Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Lou Richard.
Aye.
Motion carries to adjourn at 10:30.
All right.
All right, we are adjourned.
This meeting.
Have a good weekend, everyone.
You too.
Oh, yeah. See you.